We have a keynote speaker, and I would like to invite Paul Lambert for his keynote speech to the stage. Paul is an academic, qualified lawyer, editor, and consultant. He's the author of numerous books and articles on technology, law, and policy, including International Handbook of Social Media Law, the Data Protection Officer, and Greengrass, the Laws of the Internet. He's a contributor for the European Intellectual Property Review and edited the International Journal for the Data Protection Officer, Privacy Officer, and Privacy Council. He's a visiting research fellow at the Institute of Advanced Legal Studies, University of London. And his area of focus is neurodata and the interface with privacy, data protection, and GDPR.
Well, to start off, I'd just like to thank the Institute and the University for arranging such an important and timely a conference on these important issues. As mentioned, I'm the editor of a journal in relation to data protection issues, and particularly focused on data protection officers and privacy professionals. What I'll be talking about will be three themes. One is in relation to the importance of privacy and data protection, how privacy and data protection are increasingly shaping technology, and some of the privacy advantages. And these three themes will touch on the various talks and presentations later on. So on the first one, data protection and privacy is important and essential, but why? And there are a number of reasons for this. One is it's very important for individuals, but it's very important for companies and organizations also. In relation to individuals, there's a number of reasons, and we could spend the whole day just talking about these particular issues in relation to individuals and the interests that individuals have in data protection and privacy, their rights, their expectations, and the obligations on organizations. But I'll just say that individuals, in terms of their data protection and privacy rights, are increasingly aware of those rights and increasingly seek to enforce those rights against organizations. In terms of companies, why is it important? It's important and essential for a number of reasons. One of those is that the cost of getting data protection and privacy wrong has vastly increased. So if a company has a data breach or has some other data incident, there are very real financial and other costs. As one example, there are a number of examples where companies have lost significant share value, in some instances up to 40% of their share value. So that's very significant and has a very real world impact. You'll be aware of GDPR scale increases in fines and penalties. That's very significant. It's also significant in terms of being worldwide based as well, worldwide turnover. There can be significant adverse media attention. Something overlooked quite a lot is that there can be lost customers, reputation, goodwill. They're real issues. So if something goes wrong, organizations need to think about, well, it's an issue for the company, but it's also a competition issue as well. Your competitors will take advantage of that issue as well, and try and take on your customers because of that. So organizations and companies need to be increasingly thinking of risk, low risk, being abusive in terms of the types of data they're collecting and whether it's transparent, and the increasing awareness and expectation of individuals in terms of realizing what companies are safe companies versus risky companies. And another issue often overlooked is that quite often the database or the database of personal data of a company can be the most important or the most valuable asset of the company. So if something goes wrong, there are already examples where companies have been ordered to delete their database. So that's deleting their most valuable asset, and therefore the value of the company goes. So that's very, very onerous and very important to be aware of. And not least, it's also increasingly important for individuals personally within the company. So there are many examples now where directors and other officers within the company have lost their positions as a result of a data incident. So that's very important to be aware of. Increasingly, data protection and privacy shape technology, but how does that happen, and why does it happen? Just some examples of that. A recent quote, technology design should be a fundamental component of privacy law, and increasingly does shape privacy. A very real-world example of that is the concept of privacy by design and data protection by design, and that's recently emphasized or re-emphasized in Article 25 of the GDPR, which emphasizes things like pseudonymization, data minimization, etc. While the GDPR is recent, for a number of years, places like Canada, the EU, even before GDPR, and even perhaps surprisingly, the US have also endorsed and promoted the concept of privacy by design. And for a number of years, even multinationals like Microsoft have embraced it and promoted it themselves and promoted it to other organizations. So privacy by design and privacy by default are very, very important issues, not just for large companies, but for every organization, and also for commercial organizations and non-profit organizations. Another new issue companies and organizations need to be aware of in designing their technologies is, or have to be aware of, is that they have to design their technologies to be cognizant of children and children's issues. And obviously that's a big theme of the conference. So recently the GDPR in Recital 38 and Article 8 has, for the first time in the EU data protection law, explicitly included reference to children, and has even set out an age below which consent cannot be given unless a parent or guardian is involved. Now, there are complexities about that because there is a type of derogation where member states can vary that age 16 to a lower age, which makes it more complicated for organizations dealing with a number of different countries which have a different age. But that's a separate topic. Companies like Apple are a really good example of how privacy is shaping technology. So Tim Cook recently, commenting on AI, has said how AI, or the future of AI, must respect not only privacy and data protection, but human values. And the European Data Protection Commissioner has said that technology should be designed to serve mankind, not the other way around. So technologies must be designed to take note of and incorporate and comply with data protection and privacy. A recent book, which is a book I'd recommend, Privacy Blueprint, talks about design defaults and technologies incorporating design and privacy design into their technologies. But we already have some examples of that. Some of the Apple technologies which collect fingerprint data, face data, are already designed to include encryption, and importantly, only store that type of data on the device locally. So that means it's not going to a cloud, or it's not going to other systems, making it more amenable to risk and attack. We should also consider as well in how data protection and privacy are shaping technology, how regulators and data protection authorities are helping to shape that also. So we've got like various data protection authorities in Germany, CNIL in France, in Ireland, in the UK, Data Protection Commission, and the ICO office in the UK. They're very important in interpreting how data protection and privacy law and the GDPR should be implemented, and set recommendations, deal with complaints, which act as case studies, and how companies should, in their own organisation, interpret how their compliance or level of compliance is. It's also important in terms of cases and case law as well. There are a number of cases going on in Ireland. On the first day of the GDPR, there was a number of new data protection cases lodged. There's a case going on at the moment where a particular issue has been referred to the European Court of Justice, and Facebook are appealing that to the Irish Supreme Court. There are a number of complexities, I suppose, in terms when we talk about the UK. Yes, they have a new Data Protection Act like most member states, but it's quite complicated, and there's a whole question mark of how issues will transpire if and when Brexit occurs. Because there is a strong argument, even though it's overlooked, that data protection is actually the biggest threat to the UK, far and above anything else. if there isn't a data protection adequacy transfer decision from the EU, which it appears likely that there will not, given time issues. There are various privacy advantages and competitive advantages from incorporating sensible data protection and privacy laws and design into one's technologies. And what are they? Trust, goodwill, consumer confidence, value. When we think of value, we think of not only increasing value, but also protecting the value of the company, or protecting the most important assets or assets of the company itself. Consumers, competitors are increasingly aware of which companies are undertaking risky activities, and they're incorporating that into their choices. So there's a privacy advantage and a competitive advantage to incorporating privacy, and as I like to call it, it should also be considered in terms of pre-problem solving. So if one considers, say, one is developing a new product or service, it's much cheaper to incorporate privacy considerations from day one of concept design versus day one of launch. So if you leave it to the day before launch and you're asking privacy questions, then you may realize there are some big problems or big holes you need to rectify. So you may have to cancel your launch, or if you've launched already, you may realize the problems are so significant you need to cancel or withdraw your product or service until those issues are rectified. And even in some examples, a product may be launched and then you realize you didn't consider data protection and privacy. You can't do a workaround or fix the problems, so you have to withdraw your product entirely. So there's a big issue in the cost of development, but also loss of goodwill and face with customers, potential customers, and the market and your competitors also. So it prevents and can help prevent product recall. It's also important in reducing liability, fines, damages. So even if something does go wrong, well, firstly, you hope that your consideration of data protection and privacy prevents something going wrong. But even in a worst case, if something does go wrong, that you are able to demonstrate your documented processes for day one incorporation of privacy and design considerations for product development, that will help to mitigate any fines or damages that may ensue later on. So it's really very important to think about in terms of privacy advantages and pre-problem solving, so avoiding problems or reducing the risk or the severity of problems if and when they do occur. We've mentioned Apple already. Apple, a $1 trillion company, the first $1 trillion company. So that's a very real world example of how even if you incorporate very good data protection and privacy principles and practices, documentation, processes, procedures, you can still be the most successful company in the world. So that's very important. So Tim Cook recently said a number of things at a conference. Apple believes that privacy is a fundamental right. We cannot achieve technology's true potential without the full confidence of the people who use it, our users, our customers, and it's an important value issue for the company. So I think that there are principles, commercial principles from a really successful organization, which should be reflected in other organizations. Just mentioning that book again, Privacy Blueprint, a very recent book, has a very good quote: "Indiscreet technologies erode trust, but also consumer confidence, consumer value, the likelihood that people will sign up and become users of your product and service." So it really is really important for existing companies, but also new companies to respect consumer data protection and privacy. And things like minimizing collection, minimizing harmful design, being transparent in design, not deceptive, not being risky. These things can help prevent things going wrong, but also help you to react effectively and timely, and also show you have processes and procedures to minimize risk even when it does occur. As I mentioned, Microsoft have for a long time advocated privacy by design, and more recently data protection by design. But there are other commercial examples as well which we may not think of or may not be as obvious. Apple, Microsoft are at the forefront, but there are other companies which we might not immediately think of that also have incorporated certain examples within their design as well. Many of you will be familiar with this individual, Max Schrems. What he's holding is his data access reply from Facebook. So he was a Facebook user, asked for a copy of his data, and this is what he received in return. So it's obviously very bulky and much more data and types of data and data signals than you would immediately expect. But this is an example where when this occurred, Facebook actually did step back, consider issues. There were some commercial considerations, but they decided to revamp their processes, and now it's possible for any individual to go onto Facebook and obtain their data electronically, versus the cumbersome and costly for individuals and for the company procedure of relying on hard copy only. Now there are cost benefits to Facebook, but it is an example where design has been changed positively by data protection and privacy. Another interesting issue, and it ties in with some of the themes later on in terms of social media, online abuse, and those things. Interestingly, Facebook doesn't have, you can make your post, but there's no forward feature. So forwarding messages, communications, harmful speech, images is one of the things, just one of the things, which contributes to the scale and escalation of online abuse on the internet. But limiting the forward or preventing forwarding increases an extra cost to trolls, etc., escalating that cost on a victim of online abuse. So it's not an obvious example, but it is an example of how they actually did consider privacy and data protection and harm reduction. Another example is Google Glass. Now there obviously was a number of privacy issues with Google Glass, but at the same time they did decide not to incorporate facial recognition in the launch of Google Glass. So while it's overlooked, it is an example in a company which does have, I suppose, other issues sometimes, but it is an example, a concrete example of where there was a privacy, data protection consideration and risk mitigation consideration in not incorporating facial recognition. Data protection and privacy is also important to consider because it's a law like no other. It applies every day to every individual, to every company, and to every organization. So it's impossible to think of another law which applies so universally to all individuals, companies, and activities in daily life. So it's really, really important and really important to get right, and really important increasingly for individuals in terms of their expectations for companies and their ability and expectation to enforce their rights when things go wrong. But even if things don't go wrong and they just want to delete their data or stop using the service, their data should be deleted. We've recently had the example of the GDPR, second generation type data protection laws, followed by similar or related laws throughout the world. This year and next year, there's a whole host of other follow-on data protection laws. It'll be interesting to see how they deal with some of the new developing issues. Now, I've just mentioned in passing some of them, from facial recognition to microphones, big data, Internet of Things. These are all really, really important individual issues. Over the next number of years, we'll see how the GDPR and these new laws cope with these new technologies, whether they are sufficient, whether they need to be expanded further, whether we need even additional new laws, whether in some instances we might even need enhanced criminal laws for, say, companies that are repeat data breach offenders, or for trolls, hackers, etc. Does data protection law need to be complemented by increased penalties for individuals under criminal law? The Information Commissioner in the UK for a number of years has been calling for increased criminal laws in certain instances. Something which is a theme also for all of the all of the talks today is the issue of consent. If an individual is signing up for dozens upon dozens of websites and services and applications, how many terms and conditions are there? How many consents? How many layered consents are there? how difficult is it for an individual, particularly younger individuals, to understand and to keep track of what they've signed up for, and also how they can manage those, and how they take things down if they want to later on. Is consent really the be-all and end-all of managing privacy and data protection? Is arguably too much reliance being placed on consent? So that's a theme we will hear over the coming years. Is consent being over-relied upon? OA, online abuse, a theme which ties into some of the things we'll be considering today is online abuse metrics. If we consider any website X, how do we know that its safety and online abuse practices have improved this day, next year, the year after, the year after? What are the baselines for considering that? How do we as users, how does the company know, how do regulators know that there has been an increase in safety practices, but also a decrease in online abuse activities on that website? Arguably, we don't have any metrics, or we don't have any baseline today. So is it the case that all discussion in relation to online abuse is irrelevant, is useless? If we don't have a baseline today, how do we say next year that website X has improved? I think a lot more discussion and consideration needs to go into baseline issues and what the metrics for understanding improvements in online safety, reduction in online abuse are in future. Consider also percentages. Say, like, we're never going to get to 100% successful elimination of online abuse on website X. But say we decide it's appropriate that, say, 5% or 10% of website X's revenue should be devoted or allocated to dealing with online abuse. If website X has 1 million users this year, but next year has 50 million users, if the level of revenue stays at, I don't know, say it was whatever the static figure was, if the user base increases, does that not mean that the level of risk for online abuse has also increased? Does that mean that the level of revenue allocated to dealing with that should also increase? So while we think of website X might be good, or might have certain procedures, might dedicate a certain number of personnel, certain resources, something we can even set a monetary figure on, if that doesn't keep pace with the user population, then it's arguably irrelevant that what we think now, if next year the resources aren't there equivalent to the increase in its user base to deal with those issues. So there are two themes I'd like to suggest that kind of feed into some of the things we'll be discussing and considering later on. And then just finishing off, data protection and privacy is important for many, many reasons, from an individual's perspective, a user's perspective, but also from a corporate perspective, and the privacy advantage, and also minimizing risk, penalties, minimizing the opportunity for competitors to take an advantage or leapfrog you if you slip up with a data breach, etc. So companies should be able to focus on technology reflecting human values and being consumer-centric. And as the Apple example and Microsoft example clearly indicate, an organization can be commercially successful yet be privacy-friendly. So on that, I look forward to listening to all of the subsequent talks and taking any questions now or later on if there are any. Thank you.
Any questions? Now I start to encourage them, but I have a question to you. You mentioned during your speech the success of Apple in terms of privacy. The company started to give more importance to privacy, and we compare the Apple's behavior and success with Facebook, and you also said
I hope not too directly.
Privacy, the privacy creates competitive advantage for companies, and using this, they create really competitive advantages between other competitors. So, what do you think? In order to reach that goal, the transparency and also the accountability, one of a few important aspects of the GDPR, the principles. Are they helpful? Are these principles helpful in order to reach that goal, to create a competitive advantage?
I think new laws, new regulations like the GDPR are very, very helpful. But I think perhaps in the long term, even more important is the promotion of privacy and data protection commercial advantages by regulators. So I know for a number of years the ICO in the UK has occasionally mentioned it in its reports and documentation, but I think regulators need to emphasize and sell more the successful competitive advantages and commercial advantages of incorporating data protection and privacy per se, and also data protection and privacy design into their technologies, which must happen on day one of the design process, the concept design process, and not on the day before launch. But I think also it's important for companies like Apple. They're really good case studies, but I think they need to be more vocal in promoting those advantages also. Now, I know recently in the last number of weeks, Tim Cook has done that at a major conference in Brussels. But I think companies like Microsoft, like Apple, need to sell more the values of privacy and data protection because they do have some very good case studies there. Companies like you have mentioned, like Facebook, there are a whole host of issues there. I'm not commenting on them, but I'm just saying that even companies which have a mixed bag of issues, some good, some bad, can actually sell more their positive examples and how and why that is important. And even when they take in company X, even if company X is a mixed bag of issues, some good, some bad, the extent to which it starts promoting the positive advantages and the positive business case for those positive instances helps to improve the culture of that organization itself, or will do in the long run. So I think it's a layered answer, but I think Apple, Microsoft can sell it. Regulators do need to sell it, but even mixed bag companies like Company X, whatever that might be, can start improving its culture internally by promoting its good examples also. But also the individuals in those departments within Company X, managers, etc., they have a responsibility to sell those positive advantages also.
Thank you. I would like to ask again. Yes, we have a question there.
Hi, my name is Burak, and I'm a lawyer working on privacy and protection issues. I would like to ask, we are all talking about the positive outcomes of the privacy and protection regulations everywhere. And Europe, of course, is the frontier, is the pioneer in this. And what I would like to ask is, what are the obstacles in front of these regulations globally? Are there any groups that doesn't want this type of regulations to grow, or other countries keeping the law of privacy as their advantage. What do you think on this?
Answering part of that question, but also going back to the last question, what I should have added into that as well is that there's a responsibility on academics also to do more research in relation to the positive privacy cases, commercial cases, and analyse those, promote those, brings those into focus as well. New laws are important in Europe, but all throughout the world. But it will be a number of years before we see how effective they are. They will be effective in certain instances, but in other examples where we have new technologies or things we haven't thought of yet, the question mark will be, how does that fit into those new laws? Can new laws effectively wrap its arm around those new technology applications also? So each of those things will be from big data to AI to facial recognition, etc., etc. Each of those things will be on a case-by-case basis as to how effective new laws are in terms of promoting best practice in the application of those issues. Big issue will be, say, health data, health applications. Like you've got a variety of companies, from medical companies who would have more cognizance of complying with law, ethics, medical rules, and privacy and data protection, versus fitness tracking companies which don't have the same ethos. So you can have the very important implications from health technologies, but different companies will have different views on them. So it remains to be seen what will happen. New laws in terms of being promoted in the US, the US federal law, many companies are now jumping onto that and promoting that. It remains to be seen whether that will be an EU-style law or whether Apple will be promoting that for arguably the most positive view on it, whereas arguably some companies may have a view that they want to, yes, bring it in because we have to, but try and influence it to water it down so it's the least effective. We don't know what will happen yet. But even going back to the GDPR, it's very important, it's very good, it's beneficial for individuals, but also for organizations. And it does seek to be technology neutral, and it also seeks to be future-looking, forward-looking, future-proofed. But 2 points I would make is it's taken many, many years for the GDPR to come out, from being a concept to being drafted, to being negotiated, to being finalised, and a 2-year roll-in period. So it didn't happen just in say in May. It happened. The origin of it was a long time ago. The second point I would make on it is the GDPR is meant to have been the most lobbied piece of EU legislation ever, from a whole host of different companies and organisations. And I know some researchers have, in their analysis, they've seen some comments or submissions by MEPs, by politicians, which are just copy and paste of representations to them by some big tech players. So the amount of lobbying has been obvious and non-obvious. While the GDPR is very heavily lobbied, one can expect that there will be equally heavy lobbying for the proposed US federal privacy law. But I think places like California, individual AGs and states are very proactive in promoting, and there will be a balance there between those who seek to go for best practice versus people who try to water it down and minimize. So, but it's a moving beast, and we have to see what happens. But I think the trajectory of privacy and data protection laws and protections are good. The question is, as you're suggesting and implying in your question, can laws stay on top of new technologies which we haven't thought of? Obviously, some things are going to fall through the cracks, and we will have to deal with that as they happen. But there are question marks over some of the big data IoT things at the moment. But the GDPR is good, but it isn't the be all and end all, and what works today may not work tomorrow. So we have to constantly improve. I hope that wasn't too long.
One more over there.
Hello, thank you for your speech. I'm Martjan. I'm a legal intern and an entrepreneur at the same time. I would like to ask you about what do you think about SMEs and startups? Because the companies that you mentioned, Microsoft, Facebook, Google, they got unlimited resources. But on the other hand, startups and SMEs, they don't have the resources to allocate on this matter. In the recent years, have you had any observations regarding this problem, and how can we improve this situation, and how can we solve this problem? Thank you.
It's a very good question. The first thing I would say is, yes, larger organizations would have an advantage, and sometimes that may have a chilling effect on other organizations because they can deal with the GDPR, or they have the resources to, but they also have the resources to influence, for example, new laws in the US, which are specific or suit their commercial position in their industry, but is disadvantageous to other industries. But also more practically, you need to think of the type of organization itself. So a doctor's practice is a small organization, but the type of data the doctor's practice has is quite different, and different in sensitivity and risk to your corner shop, which has a database of people who buy weekly newspapers from it and who it delivers to. So the risk and concern issues with the corner shop are quite different to the doctor or to even other types of commercial organizations. The second point I would make is reiterating what I've said already, is that companies can be very successful a lot quicker than they could have been previously. So a company can have a small number of users today, but this time next year might be so successful it has millions of users. So technology is a blessing in terms of assisting new types of development, commerciality, etc., which is good, but it also brings risks as well. But those particularly tech-type companies are companies which heavily rely on what will be their database of customers and consumers, and to know in advance that is going to be one of their biggest assets or their biggest asset. They have an extra duty to be cognizant of putting practices and procedures in place from day one. So as I like to say, it's an issue of pre-problem solving. If you don't pre-problem solve now, it can be very hard in a year's time to retrospectively put things in place. And there are examples where companies have decided, and not, even separate to the GDPR and consent and the e-privacy regulation, companies have decided, we should have done better on day one or in our concept design stage. Let's just delete and start again. And companies do that because they see that it's easier to do that, it's cleaner, they have more commercial incentive to do that because they see that they may have a successful product. They just need to wipe the database and start again, and they've maybe proved their concept. They know they're going to be okay in what their commercial endeavor is. But because technology and consumer databases can increase so quickly, there's more responsibility on organizations, even startup organizations, to get it right from day one, from a commercial perspective, regardless of potential fines, penalties, investigations, publicity, etc., etc. So it depends on the organization and the sector that they're involved in.
The last question.
Hi, I'm Iram Sayıl. I'm a lawyer registered with the Istanbul Bar. And I was wondering if you could elaborate more on OA metrics and how we can quantitatively measure whether a company is getting safer.
As with all metrics, the starting point is data. In terms of online abuse, as an example, but not the only example, social media companies, the starting point would be to establish a baseline metric, baseline data. So say today, we take company XYZ, it would be interesting to know many such websites would have types of complaint procedures. It would be interesting to know publicly, or for regulators to know, what the level of complaints are today. And this is a simple example, and then compare that to the level of complaints next year, the year after. Then compare that to the level of user base, which is increasing, which is not. And then it gets very interesting in terms of certain potential websites and certain actual websites as to what they mean by successful resolution. So if they have X number of complaints today, in a week's time they might say X number or X percentage of them were successfully resolved. There's some very interesting issues as to whether what they mean by successful is what we would consider successful, or what the individual user would regard as successful. So there are examples where a certain thing would happen, or a certain thing would not happen, and in the company's view, they would interpret that as being successful, therefore that's resolved. Whereas the user may still be complaining because there's something viral out there on the internet or on company XYZ. That is of real concern to the individual, and the problem has not been solved, but the company has interpreted it as, under its definitions, as being not its terms and conditions, but under internal policies, as being resolved. So there's very interesting issues in terms of that. But the biggest point I would make in terms of metrics and online abuse metrics, and how we can know next year that there's an improvement, or that something is safer than it was today, is transparency. So it's transparency on the statistics that they do have, which they, for some reason, do not want to release publicly or release to regulators. But I have argued a number of times, I think the single biggest thing which would improve online safety and reduce online abuse is transparency of statistics. Because only when we see the statistics today as the baseline for today, for next year, etc., going forward, only then do we know what the scale of the problem is. And only then do we have sufficient knowledge to ask the next questions, which those next questions would then better channel and focus society, regulators, and even companies themselves, and company X versus company Y as being competitors, as to what they should do to improve company safety from a data protection and privacy perspective, a safety perspective, a competitive advantage and positive case study issue. Just tying in with that, we won't know for a number of years, but arguably, or there is an argument that people dying as a result of online abuse may not be the biggest trigger for improved online safety. It may be politics and reference to fake news and Russian web trolls. It may ironically turn out in a number of years to be a bigger prompt towards improving online safety than teenagers dying as a result of online abuse, which is sad and ironic, but that may turn out to be the case. but I would recommend individuals, researchers, and regulators to pay more attention to what websites generally interpret as online abuse, as successfully dealing with online abuse, and pushing it to be more transparent with their statistics. Because once we see how good or bad statistics are, what statistics they're not collecting, can we push them to do more things? And they do need to do more things. I hope that wasn't too cryptic.
Thank you so much, Paul, for your valuable insights and remarks. Thank you.